This is Dr. Stephen Hart's presentation, and I am Julie Gallagher. I'm president of the American Academy of Forensic Psychology. And this year we are giving the Distinguished Contribution to Forensic Psychology Award to Dr. Hart. I'm sure many of you know of his many contributions to the field of psychology, but I will go over them briefly. Dr. Hart has been on the faculty in the Department of Psychology at Simon Fraser University since 1990. He's held the rank of professor since 2001. He's also been a visiting professor in the Faculty of Psychology at the University of Bergen in Norway since 2000. His expertise is in the field of clinical forensic psychology with a special focus on the assessment of violence risk and psychopathic personality disorder. He has co-authored more than 215 books, chapters, and articles. He has served as editor of 2 scientific journals, a member of the editorial board of 6 journals, and ad hoc reviewer for more than 30 journals. He served as executive committee member of several professional organizations, including the president of the American Psychology Law Society and the International Association of Forensic Mental Health Services. He has received various distinctions for his professional work, including the Career Achievement Award from the Society of Clinical Psychology, the Salim Shah Award for Early Career Research, Excellence in Psychology and Law from the American Psychology Law Society and AAFP, and the Distinguished Achievement Award from the Association of Threat Assessment Professionals. And today we will add to his list of awards. So, Dr. Hart, congratulations on the Distinguished Contribution Award.
Good afternoon, everyone. I just want to start off by saying thanks very much to AAFP. I have to actually admit, when I first got the email, I thought, is this a joke? And then I thought, do I really, to paraphrase Woody Allen, do I really want to get an award from an association? If they're giving me one, could it really be that good? You know? But then I saw it was from AAFP, and I was actually relieved, and in part because I did, of course, I was grateful to receive the Shaw Award from AAFP so many years ago, towards the beginning of my career. And also because AAFP is a really special organization. And as somebody whose training was as a clinical psychologist, all I really ever wanted to do was to help clinicians do their work. And it's been fantastic to have associations with AAFP over the years, and some of the people that I respect the most in the world are members of this organization, and some of them are in the room today, so you know who you are. So it actually really does make me pleased and honored to receive the award, so thanks very much. I am going to talk today about a couple of issues. Some of them will sound familiar because I'm going to review the past a little bit, and then I want to move on to some of the issues that have been kind of concerning me most recently, especially over the past 5 to 10 years. So just to go back and do this again, everybody talks about the history of risk assessment. I'm not going to talk about generations because I hate that. When you get old, you hate generations. But I'm going to give you a little personal summary. So I make no claims as to the historical authenticity of this, but it just feels right to me. Between about 1980 and 1992, I would suggest to you, there was really something going on in our field. There was something in the air, and we can attribute that to a couple of things. One of them was, I think, that profound and long-lasting impact of John Monahan's work, and especially his monograph that subsequently was published and is being republished, which started to ask the question in a very detailed and thoughtful way, can we assess violence risk? And I'd encourage you, if you haven't read that before, it sounds like it's something that, from 1979, 80, 81 may be of historical interest, but it's not. It's still current today. And as I said once, in a footnote of an article, or the author acknowledgement, John basically has said pretty much everything that's interesting to say about violence risk assessment, or that's important to say about it. So you might as well go back and start there. If you haven't had the chance to read it, I strongly urge you to do so. But also around the same time, we had other colleagues, and notably Chris Webster, who was doing some work on violence risk assessment and developing a tool with his colleagues called the Dangerous Behavior Rating Scheme. I think he would probably refer to that now as an early effort, or you could call it half-baked. It was a work in progress. Also around that time, there was work on specific risk factors that seemed to be related to serious crime and violence, and including work on psychopathy by Bob Hare, starting in 1980, and the PCLR first draft manual coming out in 85, subsequently published in 1991. And then, of course, the work by John and Hank on the MacArthur Violence Risk Assessment Study, which I think formally started in 1992. You must have put in the applications for that or being contacted about it years ahead of time, like probably since you were 6 years old or something. That went on formally and specifically for a number of years, but of course has kept being a presence in our field for decades since then. And one of the important outcomes of that was the book that came out in 1994 talking about some of the specific risk factors that John and Hank thought were very important for us to look at. And this led to a kind of, I would have said, precipitating or crystallizing of things that were going on. And to me, I think, and as I've said before, 1993 was the year that everything changed for us. And it's pretty rare that I could point to a specific point in history and say, this really seems to be the date. But I would say it's 1993. And I say that for a couple of reasons. One of them was we saw in 1993 the publication of the Violence Risk Appraisal Guide. But the Violence Risk Appraisal Guide, if you go back to history before that, actually came out of something called the Violence Prediction Scheme, which is something being developed by Chris Webster working with Vern Quinsey, Marnie Rice, Grant Harris. And what they actually tried to do in the Violence Prediction Scheme was to marry both actuarial risk assessment and guided clinical judgment. And of course what happens is it's an unholy marriage. It didn't work. And as soon as they started to work on the little, what those of us who have a copy call the Little Pink Book, anybody who was familiar with that was also surprised to see that the VRAG was published actually separately and in a journal by half of the team. And it kind of proceeded along its own way and its own route. And that was really the most recent birth, or if you want to call it the rebirth, of actuarial risk assessment in the violence field. But Chris Webster didn't give up, and he took what was called the assess list, and anybody who knows Chris knows that that's an acronym. Chris can find a way to make an acronym out of anything. He managed to come up with these 10 items that he thought were very important and created this list of clinical factors, and then continued work on that, and that became the HCR20. So 1993 actually saw this schism in the field, and in Canada it was actually kind of like an east-west divide, and the actuarial stuff stayed in the east, and the structured professional judgment, as it became known, developed in the west. And you saw very quickly that developed into a couple of things. First of all was the first SPJ guide, which is the SARA, the Spousal Assault Risk Assessment Guide in 1994, revised in 1995. And then the HCR20 first version coming out in 1995. So that's how precisely we can actually date this. And since then, yada, yada, yada. Now, okay, so that's being somewhat sarcastic, of course. But really what I would suggest is we've seen a proliferation of tools, application of tools in different settings and different samples, and then different kinds of evaluation of those tools. Now, I typically have referred to that kind as a phase of consolidation as opposed to generation of new ideas, or if you want to call it kind of like incremental change rather than inorganic or rapid change. So 1993 was pretty important and led to a whole host of changes in a very short period of time. And since then, we've seen more exploration of those roots that were established in 1993, 1994. And if you wanted to look at it as kind of a dendrogram or a tree diagram, you can see that schism in 93 going the VRAG versus the assess list, and the VRAG, it becomes almost biblical here, right? The VRAG begat the SORAG, begat the MinSauce, begat the Razor, begat, blah, blah, blah. And then, of course, with respect to intimate partner violence, we have the danger assessment, Jackie Campbell's tool, or the domestic violence screening inventory, or the ODERA, the DV-RAG. With general violence, we have the COVR and the Risk Matrix 2000V, and the different kinds of tools. And of course, the number of tools keeps growing all the time. There are, if you just wanted to take sexual violence, there's like more than 50 that people use around the world right now that are actuarial tools for assessing sexual violence risk. We could do the same thing if we went down the structured professional judgment route. We could see the HCR 20 begat things like the SAVERY or the START. For sexual violence, we've got the SVR 20 and the RSVP. For intimate partner violence, the SARA, the Be Safer. For other kinds of violence, we've got the CARE, the Waiver 21, the SRP. So all kinds of different people developing different kinds of guides. But I would have said more slight changes or variations rather than something that's dramatically new or different. So what's the current status? We've had a lot of successes over the last 20, 30 odd years. We've identified a number of risk factors for diverse forms of violence in diverse settings and populations. And we've demonstrated, I think, inarguably, that we can reliably distinguish between people who have committed or will commit violence versus those who have not committed or will not commit violence, with, on average, moderate overall accuracy. So we've demonstrated, inarguably, that we are not completely useless. For which my mother is eternally grateful. But there also remains some concerns about the validity of risk assessments. And this is, I'm going to say, also nothing new. This is more a regurgitation of some of the things that I've discussed in the past. But one of the major concerns is that complexity and uncertainty, they certainly place an upper limit on the validity of either predictive or actuarial tools or preventive or SBJ kinds of tools for violence risk assessment. I've summarized it this way in the past. So first of all, one problem is linguistic uncertainty. We really don't know precisely or exactly what we're talking about. That is, we don't have a specific, precise, consensual definition of what violence is or is not. So, to be really blunt, if you want to use the VRAG, then if you rob somebody by stealing their purse, that's not violence. But if you rob a bank, it is violence. And that may or may not agree with other people's definitions of what is or is not violence. Or you could take, if we went back to the MacArthur Violence Risk Study and tool that was the violence screening tool that came out of that. If we threaten people with a weapon in hand, then it's violence. But if you threaten people with a weapon not in hand, then it's not, right? So we would actually disagree. So anybody who's studying workplace violence would find that most of the things that they are studying would not meet some people's definition of what violence is. So if we don't know exactly what we're talking about, if you don't know precisely how to define violence, how could you ever have a good theory of it? How could you ever predict it with precision? But of course, the other thing is we don't know precisely what causes violence. Does anybody have a good theory? Well, we've got dozens of them, right? They're all kind of useful, and none of them is exactly correct. We don't know the extent to which they include all the right things or exclude irrelevant things. They seem to be more useful for different types of violence or with different kinds of people in different contexts. We also have evaluative uncertainty. That is, even if we could try to define violence in linguistic terms with reasonable precision or risk factors for violence, we don't know how to measure them well. Even our best tools for assessing specific risk factors for violence are not great. And nobody believes that the best way to measure violence is by looking at the likelihood that somebody's going to be convicted of a violent crime 5 years in the future. I think most people recognize that people do bad stuff and don't get caught occasionally. And occasionally people get convicted when they didn't do something wrong. So nobody believes that the actual presence of a conviction is a perfect indicator of whether somebody has or has not engaged in violence. And then the last one is aleatory, which is the one that's a little bit troublesome for us, is even if we kind of knew precisely how to define violence, we knew precisely what caused it and how to measure things. We don't know precisely how to predict violence in individual cases using probability theory. There's a lot of philosophical disagreement about the extent to which we should use, for example, propensity models of probability for trying to assess violence risk in individual cases, whether we can use other kinds of subjectivist models, or whether we should just go back to kind of mainstream frequentist models of probability and so forth. And this is still an open question. Everybody knows that it's an issue. We just don't know really how to resolve this issue. Second concern is that the generalizability of these tools is not clear. We've got two things here. I would say we've got generalizability across samples. And in this case, what we can see is these tools lack what we call strong invariants. They don't work exactly the same way in different samples. Doesn't matter whether we're looking at same setting over time or different settings at the same time or whatever. They don't work exactly the same way. And if they don't, that makes us a little bit worried, right? All our models work very well, all our theories work very well, assuming strong invariance, but if we lack strong invariance, things start to fall apart. It's a house of cards. The second thing is generalizability across individuals within samples, which is similar to that issue of aleatory uncertainty that I just discussed. And third, these concerns pose a particular problem for the validity of predictive or actuarial tools, which carry a much greater assumption burden. So a strength always comes with a limitation. And if the advantage of an actuarial violence risk assessment tool is supposed to be that it allows you to make a specific probability statement that somebody will engage in violence over a fixed period of time as defined in a fixed way, then that means we actually have a number of assumptions that have to hold true for us to make that inference. So there's a great assumption burden when we're using quantitative tools, just by virtue of the fact that they're statistically developed, statistically interpreted, and we have to evaluate them statistically. I put it this way in the past, and I think I would still suggest that this is true, that when we have actuarial violence risk assessment instruments and they're based on a statistical model, that's actually fundamentally misspecified. Because we don't know that all the important things are in the model, and we don't know that everything that's in the model is actually correct, and therefore the weights that we assign to those things in the model are false. That's the only thing we know, right? They're not correct. And they incorporate theoretically questionable items. We tend to use really specific indicators for a lot of things. Like, for example, we may have something like the number of convictions that you've had for sexual offenses in the past. But if we don't believe that sexual offenses are actually a really good indication of how much sexual violence somebody has perpetrated, that it's some kind of an indirect reflection, why are we using an imperfect indicator and putting it into a statistical model and trying to predict something with that? It carries a whole bunch of measurement error with it. The third thing is we then hyper-optimize our algorithms. We use them to try to predict an outcome, but it's an outcome that we actually think is invalid anyway. If nobody believes that the number of convictions or whether or not you have a conviction is a perfect indicator of whether or not you actually perpetrated violence, put it another way, if you believe that that outcome contains measurement error, why are you trying to maximize the prediction of an outcome that contains measurement error? Statistically, that's just crazy, right? But I guess this is a simple way of saying it in English. It's not that those kinds of statistical tests are imperfectly accurate, but that they're perfectly inaccurate. That is, they're predictably and obviously inaccurate because we're using them to try to predict an outcome that we believe is false. But apart from that, everything's actually been pretty great. And we've made a lot of great strides. So, you know, I do highlight some of the problems because for me, we've done some good. We just haven't done good enough. We've just got more left to do. And I don't feel any shame or problem saying that, and I don't have any problem acknowledging it. I don't think it prevents me from going into court and trying to give an expert opinion. It's just I have to admit that I don't know exactly what the truth is. But what we're here to discuss today is actually justice. So validity has been defined in multiple ways. We've got several good books coming out recently discussing validity. I'd encourage you to take a look at the book by Keith Marcus and Denny Boersboom, or you could take a look at one by our colleague at Simon Fraser University, Kate Slaney, all discussing test validity, construct validity in particular. But here's a kind of a common definition in psychology by Sam Messick, which is validity is an integrated evaluative judgment of the degree to which empirical evidence and theoretical rationale support the adequacy and appropriateness of inferences and actions based on test scores or other modes of assessment. One thing here, there's a lack of consensus. There's actually an important disagreement in psychometrics concerning the extent to which the concept of validity does or can or should include explicit consideration of values. And that would include things like principles of ethics or law. Some people believe that the concept can or should or does, and some people would say it does not, cannot, and should not. So I'm just going to take as an example some basic principles of ethics. These are usually called the basic principles of biomedical ethics, or we could just translate them into English. We try to maximize good, minimize harm. We try to respect people's right to self-determination, and we try to respect people's human rights. And that's really the issue of justice that I'm going to talk about today. So I'm going to define justice in terms of respecting human rights. And here's a pretty good statement of human rights, been around for a while. The United Nations Universal Declaration of Human Rights. And Article 2 is this is language that everybody's used to because it's pretty much consistent with everybody's codes of human rights or constitutional law in general terms. I know we all agree about some differences. We disagree about some of the details. But Article 2 says everyone's entitled to all the rights and freedoms set forth in the Declaration without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, etc., etc. And Article 7, all are equal before the law and entitled without any discrimination to equal protection of the law. All are entitled to equal protection against any discrimination in violation of this declaration and against any incitement to such discrimination. So what's the concern here? My concern is that certain kinds of statuses, now we'll call them statuses in the law in Canada. We have what we call sometimes enumerated or statuses or so forth. And you could also just call them group differences or aspects of diversity, facets of diversity, may be related to violence risk, including the assessment and the management of violence risk. So age, or if you want to conceptualize it differently, maturity, or developmental stage or status, or race, or ethnicity, or culture, or nationality, language, faith, of heritage, or origin, or practice, whatever. Gender, either in terms of your biological sex, your gender orientation or identity, your sexual interest, and then physical or mental disability, health problems, health limitations, health differences. But this puts us in an awkward position because we actually have conflicting duties. One of them is we have to identify and consider the impact of those kinds of factors, statuses, group differences, on violence risk. But at the same time, we have to protect the rights and freedoms of people by avoiding to discriminate on the basis of those statuses. So we have to be very careful, right? So what I want to do is just go through and talk about a couple of cases. For me, if I trace through my personal history in this field, if I go through my biography, it always comes back to cases that I dealt with. And these cases are all ones that came up over the last 20 years or so and that really made me concerned about things. So I'm not going to talk about the issue of validity in terms of what we would typically consider to be psychometric validity. I want to just focus on that issue of justice and respect for human rights. Here's a case where a high score in the static 99 is used to determine that an offender is more likely than not to commit sexual violence in the future and therefore should be detained indefinitely as a sexually violent predator. So, apart from all the basic research claims that I think we would all agree on, and we could try to frame those questions in ways that are acceptable to everybody, there's a couple here that I think are relevant to the issue of justice. One of them is, what's the validity of the static 99 when you're using it with a young adult? So now we have somebody who's 18 years old and has been in custody for the past 5 years. And his index sexual offenses are committed when he was age 13. Now, you might just see that as a simple validity issue, as an open question in terms of empirical questions. But for me, it also raises the issue of what are you doing to protect somebody whose developmental status is and was different? To what extent are you protecting the rights of that person and protecting him specifically from discrimination on the basis of age? Also, given the content of the static 99, and given the nature of sexually violent predator statutes, how can you use a score on the static 99 to say that this guy's risk is on account of mental disorder? And more specifically, in the jurisdiction where this was, the test is, does the person suffer from an impairment of emotional or volitional capacity to the extent beyond that found in the ordinary or typical male offender that predisposes him to commit an act of sexual violence in the future, and it's actually predatory sexual violence, et cetera, et cetera. So there's a causal nexus that has to be there between the mental disorder and the violence risk. Some quantum of violence risk must be attributable to mental disorder in order for us to declare this person a sexually violent predator. But the static 99 does not contain any items reflecting mental disorder. If he's high risk on account of things that are unrelated to mental disorder, how can you claim that his risk is on account of mental disorder? If you can conceptually or statistically model his violence risk ignoring mental disorder, then how can you use the static 99 to argue that he is at risk because of mental disorder? Does that make sense to you? This is a big problem. We are failing to consider the potential role of mental disorder in this case and addressing a causal nexus, and it's the causal nexus and the focus on the causal nexus that allows us to go beyond discriminatory or group-based statements that say everybody with some kind of mental disorder poses the same kind of risk. By failing to consider it here, there's a problem. Also, just think about it not in terms of the risk posed, but the management of those risks. How could you say, given the content of the static 99, that you could conclude that the risk cannot be accommodated or managed in the community? Because part of the test here, the legal test, poses a risk of predatory sexual violence in the community to the extent that he cannot be managed safely in the community or requires confinement in a secure facility. So I'd say in these respects, the static 99 here is an inappropriate or unjust use. It raises a host of problems. And I'd say if I were a lawyer arguing this case, I would not argue it on the basis of admissibility a la Fry or Daubert. I'd say, in fact, this is just general admissibility. This evidence is legally irrelevant because it doesn't address the core legal issue, first. And second, it's prejudicial because it appears to address the ultimate legal issue and it does not. But maybe you don't care about sex offenders. Most people don't. So here's another one. How about a diagnosis of psychopathy according to the PCLR is used to determine that an offender convicted of murder poses a high risk for institutional violence and therefore should be executed rather than imprisoned without possibility of parole. So run across this on a number of different occasions in my life where I've actually been asked to be involved and provide evidence of 4 separate cases from 2001 to 2018. But actually, in the first of these cases, what we had is an African American offender who was actually 18 at the time. And one of the key questions is there cross-cultural variance in the validity of the PCLR for use with African-American offenders? And this is not just an issue of validity generalization. This is an issue of civil rights or constitutional rights or human rights, depending on what country or what jurisdiction you live in. And the second thing is, are you willing to conclude that everybody who has psychopathy is exactly the same in terms of their risk? That is, by virtue of their mental disorder, by virtue of their diagnostic status, that they are all the same? They all pose an equal risk? And that you can't accommodate that risk in any case? The third one for me is an offender imprisoned for murder is assessed using several violence risk assessment tools, PCLR, VRAG, SORAG, Static 99R, violence risk scale, sexual offender version, and determined to pose a high risk for violence if released, and therefore decides not to apply for parole when eligible to do so. But this is an Indigenous offender in Canada, and is there a cross-cultural variance in the validity of the risk assessment tools for use with Indigenous offenders? It's a key question. And the big problem for us is Simpsons Paradox. It's just really a special case of omitted variable bias, but it's also known as the Ewart-Simpson effect, or the Veridical Paradox, or the reversal paradox, or the amalgamation paradox. And it's relevant not only to groups, it's actually relevant to individuals within groups. So again, recommend you to look at some of the work by Marcus and Boersboom on this. Let's say we've got an actuarial instrument and we use it with a group of cultural majority offenders, and what we find is higher scores on the risk assessment instrument are associated with, on average, with higher probabilities of violence. That's what you'd expect, right? There's your regression line. Now let's take a group of minorities, like in Canada, Indigenous offenders, who typically have higher than average risk for violence and have more risk factors. But let's say there's actually a trend in the opposite direction, so that the higher the risk score, the lower the probability of violence. But actually, overall, if you don't separate the groups, the regression line's the same. You don't have to believe me. Look at Wikipedia. Or let's say it works the same in both groups, tolerably the same, but maybe a little bit different. You can get the same regression line. Let's say it doesn't work in the cultural majority, but it does work in the cultural minority. You can get the same regression line. What about if it works in neither group? And this is what Simpsons Paradox is supposed to refer to. So we can actually have a case where in the subgroups, the pattern is completely reversed, but overall, the pattern still looks good. So if we have a heterogeneous group of people, it may work with both groups, it may work with neither group, it may work with one, or it may work with the other. Somewhere in there. And you will never know unless you break it down into groups. So that's bias. That's the issue of bias in risk assessment. And that's non-random error due to group factors, right? Random error, we expect that. That's just always the case. We get it. It's relatively simple to fix. It's tractable. Non-random error is interference. It is difficult to fix. You actually have to know what the real signal is before you could tune your receiver to pick up the real signal. Two kinds of bias that we're interested in: evaluator bias and test bias. And I just want to make this really clear right from the beginning, and I'm going to say it till I die, basically. Could be sooner rather than later. Evaluator bias is always a problem for us. It's always a potential, yeah? Any one of us could be biased in any case that we're dealing with, on the, knowingly or unknowingly, despite our best efforts, or, despite the fact that we ignored the issue. So that's always a problem for us. But test bias is particularly problematic or pernicious because it affects highly structured quantitative evaluative devices or procedures. It's bias built into the formula. Evaluator bias, we're supposed to be able to figure out whether somebody's biased by doing a logical analysis of their evaluation. Did they pay attention to the right kinds of risk factors? Does it look like they systematically ignored or paid too little or too much attention to certain kinds of factors? We make them show their mental work, and then we try to figure out whether it makes sense. But test bias, nobody knows how those tests actually work. Nobody really knows the reason why a statistical formula pops out the way it does. I mean, it's a mathematical thing. It's not logical, right? It's not designed to make sense. It's designed to minimize error according to some preferred algorithm. And you have to do good statistical analysis to identify test bias. And test bias, you could actually divide into a couple of different areas: conceptual invariance, measurement invariance, predictive invariance. Now we're getting into an area where you might call this, if you wanted to take a look at it, you might see it in cross-cultural psychology. That's one of the big areas. Or if people who are examining gender bias, or when we look in law and psychology, when people look at gender bias in things like job selection or promotion. Conceptual variances are the latent variables or constructs being measured, or the outcomes that are being modeled by a test consistent across groups. And this requires kind of qualitative and quantitative analyses in an anthropologically emic tradition. This is not a statistical matter. It is not intrinsically empirical. What we have to figure out is whether people are sort of talking about the same thing. So for example, does a conviction for an African American for possession of marijuana mean the same thing as a conviction for possession of marijuana for a white American? That is a big question, right? And there's no research that you can do that gives you a simple little number that says p less than 0.05. You actually have to try to do some digging around and figure out what it means. But measurement invariance, this is something that we all feel a little bit more comfortable with because we can come back to the numbers. And this is really, are the relations between latent variables and test scores consistent across groups? So we could look at things like configural invariance, metric invariance, scalar invariance, error invariance. Strong invariance means you've got all of these. And good luck with that, because that requires the application of modern test theory analyses like multi-group confirmatory factor analysis, multi-group item response theory, mean and covariance structure analysis, et cetera, in very large samples, typically more than 500 people per group, with high degree of power, because you're actually predicting the null in many respects, right? If you're predicting invariance or predicting the null, the best way to find invariance is to do really shitty research. You've got 10 people per group, you'll never find any differences and you'll never be biased. So you actually have to do really good research here. What you can't do is use exploratory data analysis or classical test theory because they just don't work for this. They cannot answer the questions for you. Predictive invariance. Are the relations between test scores and criterion variables or outcomes consistent across groups? So we can look at model structure and at predictive accuracy. This requires complex modeling analyses, typically like linear multiple regression or logistic regression or event history analysis, in very large samples, again, more than 500 people per group, with high degree of power. Or if you're using the other kinds of tests which put people into bins or categories, you're going to need very large samples like 1,500 per group, per bin, to minimize type 2 errors. What you can't do is you can't just look at correlations or ROC analyses. Because for the reasons that we talked about for Simpsons Paradox, you could find two groups, one ethnic majority, one ethnic minority, with exactly the same AUC that actually perform very differently in the two groups. Where if you could lump them together and find nothing, or just the converse. And what I want to end right now is just talking about a case that came up in Canada recently called Ewart versus Canada. And it's the last one that I was discussing. Ewart was an Indigenous person. He was born to a Métis mother and a British father, Métis in Canada is mixed race peoples or mixed blood. So that means typically you've got both First Nations heritage, or that would be what we would call Native Americans in Canada, and European, typically Scottish ancestry. So you've got some basically people who are typically dark-skinned who speak French and often with sort of weird Scottish names, hence Métis. And he clearly self-identifies as Aboriginal, in part because he was discriminated against for much of his life for being Aboriginal. His own parents called him a dirty little Indian. So not surprising that he self-identifies as Aboriginal. He's serving 2 life sentences for second-degree murder and attempted murder, as well as 15 months for escape, all concurrently. Eligible for day parole in 1996, full parole in 1999, but he's never applied because all the risk assessments that came back have been negative. And he was deemed high risk according to risk assessments conducted by CSC over time, CSC being Correctional Service of Canada, including the PCLR, the VRAG, the Static 99, the SORAG, the VRSSO, etc. And he's long complained that those things are culturally biased and therefore unreliable for use with Aboriginal offenders. Now, Aboriginal offenders is the term that we use typically in the law. Those communities prefer the term Indigenous peoples, but the law calls them Aboriginal offenders. He's gone through a whole lot of grievance processes and gone to federal court and didn't have much luck. When he first went to federal court, it was said by the expert report for the plaintiff that there's a total lack of research validating actuarials with Aboriginal offenders, and CSC acknowledged that it's created its own actuarials in the past that when they tested it didn't work for Aboriginal offenders or female offenders. And they acknowledge that there are real concerns about this, but said, really we got no evidence to the contrary right now, and so forth. And they did manage to find this email in the system, which is, this is a verbatim quote from an email internal from CSC. This is a timely, Ewart's concern, in that we've already flagged this issue. In fact, the research branch has already begun to work on this, if only in a preliminary capacity. I suspect that the inmate will win his case and it will force our hand as a service, and rightly so. It has always been our position that the inappropriate use of actuarial scales and measures adversely affects our Aboriginal population. In fact, we contend that the use of these measures artificially inflates need and risk ratings. But the Correctional Service of Canada said, with the help of Vern Quincy, there's no evidence of bias in the tests. And there's no viable alternative to their use. What are we supposed to do? And Lawrence Motiak, a psychologist, also said that actuarials they're more or less culturally appropriate for use with Aboriginal offenders, a helpful conclusion. And that CSC is doing the research to try to validate their use and will revise its policies and procedures accordingly. And there's no good alternative to their use. And so that appeal was lost, dismissed. And it went back to status quo. And since then, those actuarials are still in use in CSC, and there's still been no good research validating their use with Aboriginal offenders. Now, I'm going to try to make this statement. There has been research, but it is not sufficient in quantity or in quality to conclude that there is invariance. So Ewart launched new action in federal court. And this was actually a long time ago, but it came to court finally in 2015. And he said, they appear on the surface to be biased with respect to Aboriginal offenders, and their use resulted in harm. And he focused on those, what have been called in the judgment, the impugned tests. I wrote a report for this. I was actually contacted by the lawyer who said, are these tests biased? And I said, no, there's no evidence that they're biased. He said, so they're not biased. I said, no, there's no evidence that they're not biased. There's just no evidence. I wrote that report in 2012. In 2015, I was asked to update it. I updated it by removing one letter, which is, there have been there has been no study there has been one study or something like that, none to one, basically. And certainly not sufficient to conclude that there's a lack of invariance. So my position is that there was and is just no good evidence of invariance. There's just no good evidence, period, one way or the other. The original expert for the defendant in this case was Grant Harris, who passed away during the course of the hearing, and then was replaced by Marnie Rice, who passed away before the initial judgment came out. So they both said that Aboriginal status is of questionable relevance with respect to cross-cultural bias. Marnie Rice put it this way: why would anybody expect that these tests would work differently for Indigenous offenders than non-Indigenous offenders? There's no standard methods for assessing cross-cultural bias, they said. And there are no major limitations with respect to existing research on cross-cultural bias, as many of those studies included Aboriginal offenders. For example, even in the VRAD construction sample, 5% of those people were Indigenous or Aboriginal offenders. So if it worked for the whole group, why would we assume that it didn't work for the Indigenous offenders? Simpsons Paradox. Larry Motiak, still in the Correctional Service of Canada, said cross-cultural bias is a potential and actual issue with regard to our Aboriginal offenders. And he said, you know, we did plan 10 years ago to do some research, but we didn't, due to budgetary limitations. And that those tests are, anyway, of relatively limited importance in CSC. So he's gone from saying that they were indispensable in 2007, and there was no viable alternative, to saying that they're of relatively limited importance 10 years later. The federal court judge, Felon, can you have a judge named Felon? Concluded that the plaintiff had established that the actuarials are susceptible to cultural bias. That is, on the surface, it looked like they were things that could be affected by somebody's heritage as an Indigenous person, and therefore reasonably ought not to be relied on, and said that the Correctional Service of Canada's use of actuarials are a contributing factor in decisions that have had an adverse impact on his incarceration. He chose not to apply for parole because he kept getting reports saying that he was a high risk. So those things adversely affected his willingness to apply for parole and get turned down. And the court concluded, these are direct quotes from the judgment, that the use of those tools is both inconsistent with the principles of the Corrections and Conditional Release Act by not being responsive to the special needs of Aboriginal people. There's such a strong recognition of this issue in Canada that is actually enshrined in the Corrections and Conditional Release Act. It's enshrined in the Criminal Code. And yet we have psychologists testifying that they don't see any reason to believe that it's relevant. And the court concluded there was also a violation of this plaintiff's constitutional rights without an adequate justification, and said that the court was going to issue a final order enjoining or prohibiting the use of those assessment tools in respect of the plaintiff and other Aboriginal inmates until, at a minimum, the defendant conducts or has conducted a study that confirms the reliability of those tools in respect to adult Aboriginal offenders. And that led to the Government of Canada filing a motion to stop the proceedings. So we've now had what they're calling the merits hearing, and they're going to move on to the remedies hearing. And the motion was denied because the judge who heard the appeal said, why would you stop a trial partway through? Why don't you just let it play out? If you get the decision you want, then you don't need to appeal, right? Like, this is just a waste. Because now we're going to have an appeal, and if I find in favor of the plaintiff, then you're going to get another kick at the Canada appeal. That's not fair. So motion was denied. And then the remedies hearing started. I testified for the plaintiff. Mark Oliver, Carl Hansen testified for the defendant. And we agreed actually on a number of points. And we do agree on a number of points. And Mark Oliver is a former honor student of mine, and he's a nice guy. Carl Hansen is a nice guy, and he even went to SFU a long time ago. These are both people that I like. These are both people that I consider to be good scientists. So what I'm trying to say here is nothing to do with personal enmity or any kind of hard feelings on the basis of this. But we agreed that there was important issues with respect to Aboriginal offenders and the cross-cultural validity of those tools, and that some aspects of cross-cultural validity are critical or potentially useful to research, and that would ideally use large and representative samples of Aboriginal and non-Aboriginal offenders, and that Mark Olver had done some studies that were helpful in between 2015 and 2016, but those were not dispositive. And the judge was sitting down waiting to write the decision about the remedies and what he was going to suggest ought to be done when there was another appeal from the government of Canada, and this time it was successful. And this is basically a matter of law. What they were saying is the federal court, Justice Phelan, erred by failing to require the plaintiff to establish his claim on a balance of probabilities. And they said that basically when I said that there was no evidence, that couldn't be used to conclude that the tests are inaccurate or unreliable in a material way. Now I'm just going to point out that's actually not what the judge said. The judge said that they're susceptible to bias, but what the Federal Court of Appeal here was saying was that, well, that's not good enough. Susceptible to bias and biased are different things. And this was actually appealed to the Supreme Court of Canada, and the hearing was held on 12th of October 2017. If you really have a problem with insomnia, you can find the entire thing recorded on the Supreme Court of Canada's website. And there were several interveners, all of whom argued against the decision of the Federal Court of Appeal. And there was recently a decision. So last year in 2018, the majority of the Supreme Court of Canada allowed Ewart's appeal in part. So there's really two issues. They found that CSC had failed to take appropriate steps to understand and remediate potential cultural bias and violence risk assessment tools, thereby breaching its obligations under the Corrections and Conditional Release Act. But they said they didn't find that there was a breach of his constitutional rights. So they allowed the appeal with respect to the first decision, but not the second. But in a typical Canadian way, what we call sometimes a Canadian compromise, they found a way to do this that kind of made everybody reasonably dissatisfied. So they said, but we're not going to release him. He's just free to now appeal again. They did, however, issue a declaration, which is quite a rare thing for the Supreme Court of Canada to do. And they said that they believe that he had proved that those tests were susceptible to bias, and therefore that he would not have to prove anew that CSC breached the Corrections and Conditional Release Act. So if he starts new legal action, he starts with a leg up, right? He's already won half the battle. So they said he's already demonstrated this several times, both in his grievances, formal hearings, and in appearances before a federal court. And so it cannot be said, based on the events that followed, that the grievance mechanism was effective in resolving the issues raised by him. So he won, but it was kind of a hollow victory because he's still in prison. Now, I'm going to say, overall, that case has stimulated attention to the issue of culture and violence risk assessment in lots of places. I think it kind of rings around the world. It rings true for people from a lot of different countries, from Australia, New Zealand, South Africa, people dealing in Norway with Sami offenders, people dealing in other parts of Europe dealing with Roma or Sinti peoples. So there's just a lot of people around the world dealing with indigenous groups who think that this is an important issue to pay attention to. But it also opens the door to consideration of other issues aside from culture, yeah? Gender orientation. Not just indigenous culture, but what about if we go to Canada, we find that in the major metropolitan areas, around 45% of people were born outside of Canada and born speaking a language other than French or English. What about the sentencing of any one of those people? Now, CSC has decided not to make any changes to its policies or procedures in light of that decision. In fact, there was a commissioner's directive issued the day after that decision that basically said, we've heard all this before and it's business as usual as a quote. So just go ahead, keep using the same tools and don't worry your little heads over it. Okay. So a couple of reflections here at the end. I hope that, by going through this, I've just helped to illustrate that validity is one thing, and we can all think about validity from a fairly straightforward research perspective, but as forensic psychologists, we have a special responsibility and special training to practice in a manner that's consistent with principles of ethics and law. Not just to be evidence-based, but to be justice-based in our practice. Predictive pragmatism is a pretty impoverished definition of validity, like it works okay. And as I said before, good and good enough are two different things. Good as better than chance is not necessarily good enough in terms of ensuring that we're practicing in a way that maximizes not just psychometric validity, but other aspects of justice. So what we really need to do is we need to put the value back in evaluation. It seems strange to us that when we evaluate tests and we evaluate them with respect to their validity, that we would think that values has nothing to do with it. And I would argue that it just does. And while we're thinking about those values, let's not forget about justice. I'm going to give you a little quote from back in, actually the title for this slide used to be Shit I Said, but I decided that would be rude. So, well, we should abandon the practice of absolute predictive risk assessment. Some of us who work with adults in our scientific zeal have allowed ourselves to be used as a justification for draconian political decisions and social policies without a fight and even without a doubt. I fear a repeat of major historical blunders and embarrassments in psychology, such as the misuse of research on intelligence to justify exclusionary immigration policies and compulsory sterilization, or misuse of research on personality and illness to argue that there's no evidence that smoking causes health problems. If psychologists claim that they can, either in theory or in practice, identify with great accuracy who will and will not be violent, then it's only logical for policymakers to target these people for extreme incapacitative measures. So that's from 2004, right? Actually from an APLS presidential award address that I gave back in like 2001. This is one prediction that I don't want to be right on. Later on in that article, I said the way forward, I think, is to reconceptualize violence risk assessment to recognize its complexity and uncertainty. We must redefine risk in a non-quantitative way, that is, not in terms of simple number or set of numbers, which you'll find that most experts in the field of risk analysis believe is the case. A way that gracefully reduces its emphasis on specific probabilities, and a way that recognizes it is an inherently human process, a perceptual, a constructive, an interactive, a social and political process. Thanks very much.